As I'm listening to all of you talk, especially you, Ms. Durham, I am reminded of my own experiences. I was a working mom, an educator who had an uneventful pregnancy. I was not older or, or I did not have any complications. And what I thought was a reasonable accommodation became a tremendous inconvenience. I was a classroom teacher, and all I needed was to go to the bathroom, which I thought was a reasonable request to ask. But you can imagine in a high school with more than 1,000 kids, to get coverage, I was often told, well, you just had your break, or we only have 2 more periods before it's time for lunch. And thinking, but I have to go right now, was just something that I dealt with, which led to further complications with bladder issues. So what started out as an uneventful pregnancy ended up having complications as a result of this minor accommodation not being met. I delivered my son on the last day of school, so all I wanted to do was work. But part of that was not that I was so brave or strong or altruistic. I was thinking about I need to save my time for the other side of this pregnancy because I can't afford to be out of work without pay. So I absolutely get it. What I don't get is the idea that pregnancy is some kind of unforeseen limitation for a country. For a company. We've heard that the majority of women work and that 75% of those women will likely become pregnant while in the workplace. So I want to get to the point about just the ability to perform essential job functions and what that means, because we're hearing a lot about workers, the need to be treated equally. I don't think this is an equality issue. This is an equity issue, because last I checked, men can't get pregnant. So the only people who will be affected by this are women who get pregnant on the job and are asking for something that other employees will never have a need for. Ms. Bass, would you mind responding? I'm sorry, one second. I always forget to do this. Madam Chair, I have 2 documents I need to submit for the record. A document from the National Women's Law Center and a letter from Senator Elizabeth Warren in support of Pregnant Women's Fairness Act.
Without objection.
Thank you. Back to you, Ms. Bass. Would you mind responding to the concerns around known limitations in this bill? Because in my experience, you've heard just from the people on this panel, every pregnancy is different. So how do you define, the experience of a pregnancy as a known limitation?
So in most of the states that we've worked in, it's been rather easy to define and to be able to explain that pregnancy itself is not a disability, but limitations or medical needs arising from pregnancy could trigger the need for an accommodation. So the law uses the term, so the PWFA uses known limitations to reflect those scenarios where there is a physical or medical need for an accommodation, and it must be known to the employer. And do you want the essential functions question? Was that a related?
Yes.
Yeah, so.
Because I didn't hear going to the bathroom in that list of essential life functions.
Right, so you make an important point that pregnancy is only temporary. That is for sure. We know that. It is not. So needing to have some essential functions temporarily excused for a limited duration is reasonable. And in fact, there are some cases in the ADA context that say just that. Because we have a reasonable we would have a reasonable time frame, which in some instances, and certainly not all, where a woman wouldn't be able to perform the essential functions of her job. Do you really think a pregnant worker who can't lift over 40 pounds for a few months should be sent home and lose her health insurance? Even though it would be reasonable and not an undue hardship to her to have help lifting or transfer to another department when there are open positions, or when their coworkers often want to help them. That's what we see all the time. The coworkers want to work it out. And then HR gets involved and points to a piece of paper and says, oops, you can't do the essential functions of your job, you're out. That doesn't make sense. We need a way to keep pregnant workers working. And on occasion, if they need a transfer or because in the near future, they will be able to perform their essential functions of their job, that should be workable. And again, if this is all an undue hardship, the employer need not provide the accommodation. But the law would require the employer to consider the accommodation request, rather than just pushing the pregnant worker out, and then, all the devastating economic consequences that often flow from that.
Thank you. I see my time is about to expire, so I'll yield back.